Well, hello everyone, and welcome to this employment law session. I am your host, the employment lawyer Lior Samfiru. I am one of the founding partners of Samfiru Tumarkin LLP, and I'm here today, like I'm here every Wednesday at this time, to talk to you about employment law, to answer your questions, most importantly about employment law. Hopefully, help you solve some of the workplace issues you are dealing with so that you know what to do if you're dealing with a problem. It's not always sunshine and rainbows at work. Sometimes we have difficult issues. Sometimes we have problems. Maybe our boss is doing something illegal. Maybe our company is not treating us properly. Maybe we lost our job. Well, guess what? In all those situations, you have rights. You have the law on your side. There's things you need to know. There's things you can do. There's rights that you have. Oftentimes, too many people don't know what those rights are. Well, on this session, I'm going to tell you what those rights are. I'll answer your question. I'll tell you what to do. I'll tell you if something is legal or illegal. So if you're dealing with a workplace issue, you don't need to deal with it alone. I've got your back. We can talk right now about the solutions that are available to you. Again, I'm Lior Samfiru, the employment lawyer, and this session is live. So if you're watching me right now, you can see your screen. There's a box there. You can type in your question, hit enter, and I'll see it and I'll read it. Whether you're on YouTube or Facebook or LinkedIn, you can do that. Ask the question right now. Let me help you over the next 30 minutes. Now, before I start answering questions, I want to give you another resource you can go to. If you want to connect with me and my team off air so that we can roll up our sleeves and get to work to actually help you solve your workplace issues, what do? Easy. You go to employmentlawyer.ca right there. Employmentlawyer.ca is the way to connect with me. Phone number is there. Email address is there. You can fill out a form if you prefer, and we'll call you. There's also resources there that you can read more about employment law and learn more and educate yourself. So employmentlawyer.ca is your one-stop shop for anything and everything employment law. But that's for after. Right now, I'm live here with you to talk about employment law and make sure that you understand your rights. Again, I'm Lior Samfiru, the employment lawyer. I think we should get started answering some questions, but take your time right now, but not too much, of course. You want to ask your question so that I can get to it before the end of the session. Well, let's see. Our first question today is from YouTube, and it comes from Desi. What can I do if my employer is making my mental health decline? There's a lot of discrimination, retaliation after filing a complaint, internal investigation taking over 2 months. So it sounds like you've done what I would have wanted you to do, is you've told your employer that there's a workplace problem, that you're being mistreated, and now they're investigating. It shouldn't take this long. So I would want you to follow up with your employer in writing. What's taking? If you're is because the company has not treated you properly, hasn't dealt, you may be able to say that it's as if you've terminated me. Sorry, if I just broke off, what I was saying is, if your employer was not treating you properly or not dealing properly with the harassment, you may be able to consider your employment as being terminated. You don't have to continue working, and you can force the company to pay you severance. The other thing you can do is that your mental health is declining. Talk to your doctor about giving you some time off work, at least until maybe your employer deals with those issues. If you have a doctor's note saying you need to be off, you can be off. In the meantime, you can apply for EI benefits. If you have a short-term disability plan through work, through your benefits plan, you can apply for that as well, but it starts with your doctor. Of course, if you're a victim of workplace harassment, mistreatment, a toxic work environment, and your employer is not doing something about it, you contact me, okay? You call me and let me help you. Maybe we get you out of there and get you compensation. To connect with me, Desi, or anyone, very easy to do. Employmentlawyer.ca. Again, employmentlawyer.ca. That address is on the screen right now. Use it. That's the way to reach out. All right. Thank you for that question, Desi. Sorry you're dealing with those issues, but I gave you some thoughts on that. If you're just joining us right now, welcome. My name is Lior Samfiru. I am the employment lawyer, and I'm here talking about employment law and taking your questions live. This is live opportunity for you to ask questions. to get educated, to have workplace problems resolved, hopefully. So don't be bashful. Ask the question. I'm going to continue answering right now. All right, our next question, again from YouTube, from GR. I worked for 20 years at a franchise, moved to head office, and worked for another 24 years. The head office recognized my service when I moved over. Is severance recognized from the date of hire or from recognition of service? Well, they're the same thing, right? Because the date of your employer, you were hired 44 years ago and they recognize your service 24 years ago. So it's the same thing. So you're a 44, wow, that's a lot, 44-year employee. So that's how severance is going to be calculated. Now, here's the reality. It may not make a huge difference if you're a 44-year employee or a 24-year employee, because severance, the maximum severance usually you can get is 2 years pay. And you could probably get 2 years whether you're 24 or 44. It's that many years that you'll probably get the maximum either way. But yeah, if they've recognized your service, you're a 44-year employee, you better believe you'll get 2 years of severance here if they let you go. And that's very important. Oftentimes, when either a business is sold or you're transferred to a different department, your seniority follows through with you. And that's important because the more seniority you have, the more severance you'd be owed down the road if you are let go. More seniority or more year of service equals more severance. And by the way, for everyone out there, no, guys, it's not a week per year of service. It's not 2 weeks per year of service. It's a heck of a lot more. So while I'm at it, let me tell you how you can find out yourself how much severance you are owed if you want to know. Again, not a week per year service, not 2 weeks, much, much more. If you want to know how much severance you're owed, it can take you a few seconds only. All you do is you go to pocketemploymentlawyer.ca. That address is on the screen right now, pocketemploymentlawyer.ca. And when you're there, you just click on the severance calculator. That's it. You click on the severance calculator and you answer a few questions and you'll find out if you're owed 10-month severance, 24-month severance, something else. It's all free. It's all anonymous. It's there for you. You don't have to put in your phone number. You don't have to put in your name. You don't have to put in the company's name, credit cards, none of that. It's just there for you to educate you and inform you, because I hate the idea. I hate it that people believe, if I'm let go, I get a week for every year or I get 2 weeks for every year. Nonsense. Not even close. Don't believe me? Check it out yourself at pocketemploymentlawyer.ca. And if you want to, only if you want to, when you do that, there's a button there that you can use to contact myself and my team so we can actually help you get the severance you're owed. Don't ever accept that severance offer without checking out the severance calculator at pocketemploymentlawyer.ca. But right now, I'm live, me, the employment lawyer. Let's continue answering questions. Ask yours. You have time. Type it in. Let me take a crack at it and to help you by answering it. All right, next question from Smashley. If my employer moves the business to a new location a few hours away, is it considered resigning if I don't accept a position at the new location? So the question is not necessarily how far away the location is. The question is, how is it going to impact you? Because they can end up moving far away, but it can end up being closer to where you live. So the question is this: if the move is going to mean an extra hour for you to get to or from work, an extra hour a day, then that could be a constructive dismissal. So in other words, if you don't accept this, if you don't make this move with the company, you can consider your employment as being terminated and require the company to pay you severance. So actually, it wouldn't be a resignation, it would be a termination, and you would be owed severance. And that could be many months of pay that you would be owed. So it's not about how far they moved, it's about how it's going to impact you. Again, hour generally. If it's the move is going to mean an hour or more extra above what you're doing now, constructive dismissal. But before you respond to the company, before you say I'm going to move or I'm not going to move, let's talk off air. We got to do this right. The devil's in the details, right? So you want to connect with me, and so we can have that private discussion, Smashley. And to do that, easy, employmentlawyer.ca. Again, employmentlawyer.ca. And of course, if you have a follow-up question right now, feel free to ask it. Be happy to answer it for you. So thank you for that question, Smashley. A very good one. All right, I'm going to continue answering questions. You ask yours, guys. I'm Lior Samfiru. If you just joined us, they call me the employment lawyer because, well, I'm the employment lawyer. and I'm here live answering your questions. All right, next question comes to us on YouTube from Delia. If you're on working notice and the employer changes or extends your termination date, do they still get credit for the prior period of working notice, which affects my severance? So if your employer gives you just one extension, generally speaking, they get credit for it. If they give you multiple extensions to the point that now you're not even sure if you're going to be let go because they've already extended it a few times, maybe they're going to extend it again, I'm not sure, then no, they lose the ability to rely on it. To get notice of termination, the whole point of notice is that you have a clear and unequivocal end date. So if they extended one time, generally they can do that and still get credit. If they extended multiple times, potentially they lose the ability to rely on it completely. And that's a good thing for the employee, because if your employer can't rely on the notice that they give you and they still let you go, well, they have to pay you severance. They don't get to reduce the severance by the amount of notice that they gave you. So remember, generally speaking, if you're let go, your employer can do one of two things. Either they can let you go right now and pay whatever severance you're owed, maybe that's 10, 12, 24 months, whatever is owed to you, or they can give you advance notice. The amount of notice that they give you counts towards your severance. So for an employee, I would expect most people would say, I'd rather sit at home and get paid rather than continue working. So that's why if your employer doesn't get credit for the notice they gave you, you get paid more, and that's, for many people, would be a good thing. So thank you for that question, Delia. Any follow-ups, please ask them. I'm happy to answer. Let's see. Lots of questions coming in. Come in. I want them. I want every question. No bad questions here today. I'm telling you right now, you cannot ask me a bad question. There's only answers and solutions. So let's get answering questions continuing right now. Janice on Facebook. Welcome, Janice. Janice has a next question. I'm a bookkeeper for a small company. My boss, the owner, is allowing us to bank balances, allowing into the bank. I'm not sure what you mean, balances. I have brought this up in writing that I am unable to do my responsibilities. He said, wait till the statement comes in the mail and post transactions. No, not ideal. I'm not sure exactly what you're saying. I don't know exactly what the issue here. Allowing into the bank balances. I don't know what you mean by that, Janice. So maybe there's something you or a typo there or something. So feel free to ask that issue again, because I'm not sure exactly what the concern is there. All right, continuing to get questions. Sunny Days has our next question. Several employees emailed and personally spoke to HR about a team lead who was bullying employees and treating her team like kindergarten children. No exaggeration. We were told our emails and meetings with HR were confidential. We recently found out these emails were shared. How do we go forward knowing everything we say confidentially is being disrespected? On top of that, nothing has been done to remedy the situation. So your employer has several obligations. Number one is to protect you, and that means, of course, making sure that whatever you tell them is kept in confidence, so you're not suffering because of that, and certainly to rectify mistreatment. If your employer doesn't do those things, you can potentially consider that a constructive dismissal. Here's the thing: there's no way to force your employer to be a better person, right? There's no employment law police that comes in and arrests someone if they're not good people. But what you can do potentially is consider your employment as being terminated because of what your employer did. That's one option. Another option is, if I send your employer a letter, see how fast they do things better, okay? They're going to do a whole 180 once they hear from me. So if you just want out of there, you can potentially be out of there with compensation. If you just want your employer to do better, potentially just by hearing from me, they will do better. Either way, there's options that you have here, Sunny Days, and happy to talk to you. But before you do anything, don't walk out of the job, don't do anything without contacting me first. As I was saying earlier, the devil's in the details, right? So I want us to have a proper discussion before we actually move ahead on anything. So to connect with me, very easy to do. Just go to employmentlawyer.ca. You see that address on the screen. Again, it's employmentlawyer.ca. All right, let's see. Continuing to answer questions. Pierre on Facebook. Injured worker in 2000, wrongfully diagnosed, tortured and rendered forced back to work before doctor's recommendation. Still needed operation. Okay, I think you say in September of 2001 you got let go. Unfortunately, you're out of time. There's a 2-year limitation period, Pierre, so there's nothing that you can do for something that happened 20 years ago. So unfortunately, you're out of time here. That's bad news. That's why you contact me, you contact an employment lawyer as soon as an issue arises. We can't do anything about something that happened that long ago, unfortunately. All right, let's see. Jade. I worked for a small family-run business for 3+ years. I have been terminated on the spot without cause, without any notice, and without any termination letter. I was given only my 2 weeks of unused vacation pay and my hours worked for this pay period. Well, I have an issue with my case as I had never signed an employment contract. No, not signing an employment contract is fantastic. You don't want an employment contract because an employment contract limits your entitlements. Here's my concern. If you don't have a termination letter, your employer can lie and say you resigned. So we don't know you anything. You resigned. So what I want you to do, number one, right now, I want you to email your employer or text your employer. Email works great, saying, I confirmed that you let me go on April 27th, whatever the date was, at 5 p.m. I'm still waiting to get my record of employment and my termination letter. When can I expect it? Something like that, just to confirm that they let you go. As soon as you send that, you call me, okay? Because you've been there for 3 years. I don't know your age or what kind of a job you were doing, but you could be owed anywhere from 3 to 6 months pay, potentially even more than that. So obviously you're owed a significant amount of compensation. So not having an employment agreement, that's great. That's the best news ever. But I want you to send that email confirming that they let you go. You don't want the company to say, oh gosh, we have to pay her money. Let's just say that she resigned. So you don't want to become a he said, she said. So send that email as soon as possible and then contact me. Okay, Jay, to connect with me, very easy to do. Employmentlawyer.ca. Again, employmentlawyer.ca to connect with me. Happy to chat with you. Address is right there. Send that email, then contact me. All right, continuing to answer questions. Kyle has our next question. I just obtained, I'm assuming you mean retained. I just retained one of your colleagues, Mr. Albert. I got denied my approval for my short-term disability. I'm suffering from anxiety and depression due to a family crisis. So you're saying that your workplace is contacting you and harassing you. Well, I mean, I want to see what they're saying, how they're contacting you and how they're harassing you. So you may want to connect with me as soon as possible so we can have that discussion, Kyle. Again, employmentlawyer.ca to connect with me. I want to see exactly what they're doing. So employmentlawyer.ca to connect with me. Desi has our next question. By the way, I'm going to answer Desi's question, but I want you to ask yours. You still have some 10 minutes or so. You have time. I promise you, if you ask your question right now, I'll get to it and I'll answer it. So ask your question. Desi says, my employer said that they would be letting me go because of permanent medical restriction after a workplace incident. Now they changed their mind. Can they do that? Well, I mean, if your employer is able to accommodate you, yeah, they can do that. They can certainly accommodate you because that's their legal obligation. So if before they thought they couldn't accommodate you, now they found out they can accommodate you, well, that's a good thing, right? So if they accommodate you according to what your doctor says are your limitations, that's good. So you'll be accommodated, and hopefully there'll be no more issues. If they won't properly accommodate you, or if they do anything to you, that could be a human rights violation. That could be a constructive dismissal. So you want to reach out to me as soon as that happens. So you can't be let go because your employer just doesn't want to accommodate you. In this situation, if I'm understanding correct, they understand their obligation to accommodate. And as long as they accommodate you properly, then that's okay. That's a good thing. So thank you for that question, Desi. Any issues, you know what to do. Reach out to me through employmentlawyer.ca. Again, employmentlawyer.ca. I'm Lior Samfiru, the employment lawyer, live here answering your questions about employment law. Okay, let's see. Smashly has a follow-up. Would my employer telling me about the move be considered notice period? I've worked there for almost 10 years. Move is in 3 months. So yes. So if your employer told you, or I should say gave you 3 months notice as an example of the move, that 3 months counts towards your severance. So you've been there for 10 years. Depending on your age and the type of job, you could be owed, let's say, 12 months severance. But it could be more, it could be less, depending on your age and your job. So if you're owed 12 months severance, but you got 3 months notice of the move, well, then you're owed 12 minus 3, that's 9. So that's how much they would owe you. The amount of notice that you got, as long as it was in writing and it was clear, that notice counts towards your severance. Hypothetically, if you got 12 months notice, that could mean you're not owed anything. But that's how that works. If that makes sense, let me know. And if you're not going to do the move, if you're decided that you want to just pursue constructive dismissal, we need to connect as soon as possible. Don't wait till the move actually happens. Let's connect now. Again, employmentlawyer.ca to connect with me. And that's the way to do it. All right, guys, still have some time here. I'm going to answer some more questions, but I don't want you to be on the fence. Should I ask a question? Should I not ask a question? Of course you should ask a question. That's why I'm here for, right? For you to answer your questions. So let's talk about it right now. Again, I'm Lior Samfiru, the employment lawyer, and our next question is from YouTube, from Kay McLaughlin. Is there any course of action I can take when my company refuses to deal with my manager after he has made inappropriate sexual comments and has criticized my performance as it relates to my disability? So the key here is to put in writing to HR what your boss or what your manager has done, and specifically tell them, I'm asking you to please help me and deal with this in writing. You may have already spoken to them, but I want it in writing so that they can't deny it. I don't want the company later to say, oh, we didn't know, you never told us. In writing. If you put it in writing and they don't do anything, they don't deal with it, they don't fix it, they don't address it, potentially human rights violation, potentially constructive dismissal. That's where the law comes in and helps you. And to take advantage of those legal remedies, you contact me, okay, employmentlawyer.ca. But first step, make sure your employer is told in writing that there's this manager that's mistreating you, sexual harassment, etc., bullying, whatever it is. And number one, that there's this issue. And number two, I want your help, HR. So please help me. Too many times companies say, oh, you never told us. We didn't know. You left, but we only found out after the fact that you were mistreated. Don't let the company say that. Then you avoid that by putting it in writing. Okay. My rule, maybe you've heard me say this before, that if it's not in writing, it doesn't exist. So put it in writing, protect yourself, and then reach out to me. Company by law must deal with workplace harassment. They have to. Okay, they have to deal with bullying. They have to investigate. They have to take it seriously, and they have to do what they need to fix the problem, to get rid of that issue. If they don't, that's illegal. You contact me again, employmentlawyer.ca. All right, let's get a couple more questions answered. Question on YouTube from Liddell. I am classified as an independent contractor. I lease a vehicle from a company daily. I pay my own insurance. I'm required to wear a uniform and have surveillance cameras in the vehicle with me that the company uses to monitor. Am I an independent contractor? Now, assuming you work just for this company and you work regular kind of full-time hours, or at least regular hours, you're probably an employee. You've been misclassified, okay? If you look like an employee and you act like an employee, well, you know what? You are an employee. So it's not a question of what they call you or what they say you are. It doesn't even matter what you say you are. The law determines that. So in this case, you wear their uniform. They obviously supervise what you do because there's surveillance. You do this just for them and regularly. You are an employee. And if you are an employee, I mean, you have certain rights. Number one, you have the right to overtime, vacation pay, holiday pay. You certainly also have the right to severance. What's important to remember is if they let you go, they'll probably say, oh, we don't have to pay you anything because you're not an employee. You're a contractor. Not so fast. If you've been misclassified, then you really are an employee, not a contractor. You're owed severance, and that could be as much as 2 years' pay. I've handled hundreds of cases over the years where someone has been misclassified as a contractor. Don't let that happen to you. Now you know your rights. And by the way, I mentioned pocketemploymentlawyer.ca. When you go to pocketemploymentlawyer.ca, we have a tool there that allows you to find out if you're an employee or a contractor. So just click on that tool, answer a few questions, and it's going to give you an assessment of whether you're an employee or a contractor. So thank you for that question, Adele. All right, next question on Reddit from Hamster46. Can you negotiate severance if there is a termination clause in the employment letter? So oftentimes what employers try to do is they try to limit your severance in the employment offer letter or in the employment agreement. Now, the good news is that in many of those agreements, most of them, 80% or more, that termination clause, that termination term is not enforceable. It's not drafted in the exact way that it needs to be drafted in order to be enforceable. It happens all the time, probably 80% of the time. So chances are that even if you have a clause that tries to limit your entitlements, it doesn't do that properly, and you're still owed your full severance. So that's why I don't care if you sign an employment agreement or not. If you lose your job, you call me. You may think, oh, I have this agreement that limits me. There's nothing I can do. Absolutely not. You may still be owed your full severance. That could be 2 years of pay. Sometimes it can even be more than that. So connect with me always, employmentlawyer.ca. All right, Danielle has our next question on Facebook. I was a seasonal worker. The owner sold to a new owner. She didn't hire me back the day before I was to start. What am I entitled to? So yes, you're absolutely owed severance. It's the old owner that owes you the severance. And I don't know how long you've been there. I don't know what kind of a job, but you're owed severance. So absolutely. So here's how you find out, Danielle, how much you're owed. Go to pocketemploymentlawyer.ca. I'll give that address to you again. It's pocketemploymentlawyer.ca. You can also see that on the screen below me. And click on the severance calculator. When you're there, you just answer 3 questions, and it's going to tell you how much severance you're owed. So that's step number 1. Step number 2 is contact me. Okay, go to employmentlawyer.ca, contact me, and let me help you get the severance that you're owed. So seasonal workers that are not hired back are also owed severance. Okay, so check it out and call me to get that severance. Okay, let's take one last question that just came in from Mason Best Games. Great. I was released last week, 1.5 years on 2,800 severance, due date tomorrow. I approached management last week as the job duties changed and now released. Okay, so companies allowed to let you go. It's a question of how much severance you're owed. You've been in 1.5 years. Now, I don't know what kind of a job you were doing or what your age is, but you're potentially owed 3 months, 4 months, even 6 months of severance. Okay, so I would expect that's much more than $2,800. So we need to connect off air to have that proper consultation to find out what you're owed. Again, employmentlawyer.ca, so that we can have that discussion. Connect with us through employmentlawyer.ca, and let's make sure you get what you're owed. That date doesn't really matter. Your legal rights don't expire tomorrow. Your legal rights don't expire for 2 years. So the key is to get proper advice so that you don't sign off on less than you're owed. You don't want to accept $2,800 and realize that you were owed $28,000, right? So let's do the smart thing, the right thing, and connect to employmentlawyer.ca. All right, lots of questions today, guys. This is the time that I had for today. Again, I'm Lior Samfiru, the employment lawyer. Thank you for joining me. My colleague, Alex Lucifero, is going to be on here tomorrow, 12:30 p.m. Eastern, to answer more of your questions about employment law, about disability law. So join Alex tomorrow, 12:30 p.m. Eastern. I'll be back next week as well, but don't wait until then. Don't even wait until Alex comes tomorrow. You can connect with myself, with Alex, our whole team right now if you want, all you need to do is go to employmentlawyer.ca. Let's have a private discussion, a private email exchange. Let's have a proper consultation. Employmentlawyer.ca. Guys, thank you for joining me today. Great questions. I'm always happy to be here, have this opportunity to talk to you, to answer questions, to help you. I'm Lior Samfiru. I'll be back to you soon, and look forward to it. Guys, thank you. Take care. Bye.